There we go. And it's my great pleasure to be able to introduce our speaker today, Devika Shankar, who is an assistant professor of history at the University of Hong Kong. So that's why we've got a slightly different time for our seminar today, because she's been incredibly generous in joining us across time zones. And that's why we've kept the seminars in hybrid format so that we can still have a fantastic array of speakers and participants from not only across the country, but across the world. She's a modern historian of modern South Asia and the Indian Ocean region, and her research interests primarily lie in environmental history, legal history, and science and technology studies. She's currently completing her book manuscript titled An Encroaching Sea, Nature, Sovereignty and Development in South Asia, which focuses on the port of Kochi in southwestern India and its transformation in the 20th century. She has also published articles on the history of water laws, princely sovereignty and land acquisition in the South Asian continent context, and it sounds as though we'll have some of these themes in today's seminar. So I'm delighted to invite Devika to talk to us about freedom of the fish, water law and property in colonial India.
Thanks so much, Jessica. And so thank you all for coming. Thanks, of course, to Jessica and Ruth for organizing this event and for giving me a chance to speak as part of this very exciting seminar series. So in keeping with the seminar's current theme, that is extraction, today I'll be talking about the legal questions generated by the attempt to extract more fish from water bodies across British India, and the way in which judges and colonial administrators attempted to grapple with these questions. And I'm going to be doing this through a focus on a few very important and influential legal cases that came up for consideration across in courts across British India. So before I get to these judgments and before I sort of discuss some of these judgments in some detail, I thought for the sake of clarity, it might be useful to give you a sense of how I first got interested in water and fish in the first place. Because in a sense, this research that I started doing 2-3 years ago now was a bit of a diversion and a digression from my sort of primary research project that Jessica just mentioned. And that is that for the last several years, I've been working on a port, or the history of a port development project in southwestern India in the port of Kochi. And so I wrote my dissertation in 2019 on various aspects of the development of this port under British rule. And I'm currently finishing my book manuscript based on this research. But when you work on ports in this part of India, sooner or later, you come across a lot of references to fish. And this is partly because in Cochin, much like in most other parts of the world, the expansion of port infrastructure often came at the cost of local fishing communities. And there was a way in which the expansion of port infrastructure, there was a sort of clash between the needs of port authorities, the needs of shipping interests, and the needs of fishing communities. But this sort of clash between the needs of fishing and the needs of navigation was especially acute around Cochin and across much of India's southwestern coastline, because one of the more popular modes of fishing in this region involved the use of fishing stakes. Now, fishing stakes, as you can see, involve the use of, or the planting of these long sort of poles into the beds of different water bodies, and the net would be planted sort of just below the surface of water. Now, as you can probably imagine, looking at this image, port authorities were not big fans of fishing stakes. So they thought of these stakes as obstructions, as hindrances to the free movement of ships in and around ports and harbors. And they thought of these stakes as hazards that could cause a lot of accidents. And so from the late 19th century onwards in particular, especially after the opening of the Suez Canal, as traffic around the Western Indian Ocean increases, as traffic around ports like Cochin across India's southwestern coastline increases, you begin to see more attempts on the part of the colonial state to regulate the planting of fishing stakes in and around harbors in different parts of British India. And so this is the context in which I first began to come across a lot of references to fishing stakes and fish in correspondence relating to the port of Kochi. But in Kochi, the regulation of fishing stakes was a little more complicated than in certain other ports across British India. And this was because if you look at the map on the left, the port of Cochin was a sort of British enclave surrounded by princely states. So princely states in the South Asian context refer to semi-sovereign territories where British rule was exercised indirectly. And if you look at the map on the right, a lot of the waters surrounding the harbor were actually under these princely states. And for these princely states, fishing was a very important part of their local economy. So as the British tried to increase the regulation of or tried to restrict the placement of fishing stakes around harbors like Cochin, these princely states tried, at least they couldn't really stop this from happening, but they tried to stall this process in whatever way possible because fishing was so important for their own revenues. And in this context, one of the princely states that was also called Cochin commissioned this report that was published in the early 1900s. And this was the report that first got me interested in the question and looking at some of the issues that I'm going to be bringing up today. And so this was a report that was written by a person called Abraham Salem. And this report sort of talks about various aspects of fishing, the importance of fishing, what is the value of fishing in this area. But in this report, the author also mentions something that I thought was very interesting, and which was that he mentions that there is a very important or very fundamental sort of difference between the way in which the how English law treats water and the way in which Cochin state law treats water. And he says that in English law, water is considered to be something that you can't possess. So you can't have private property rights over large water bodies. But he says, unlike land, and so there's this idea that I'll come back to, the idea that the very materiality of water is such that it doesn't really lend itself to conventional property rights. But he then sort of turns to the Cochin state scenario, and he says that the Cochin state doesn't quite sort of recognize such a binary opposition between land and water, and that it rents out parts of the backwater much like it rents out land to agriculturalists. And so I thought that this was interesting to sort of note this sort of fundamental difference in approaches to water and water rights. And so when I finished my PhD in 2019, I thought, and I was sort of desperate to not start working on my book project. I thought that this would be an interesting sort of distraction, and so my plan was to go to the Cochin State Archives and to look at whether these approaches had given rise to legal disputes. Because I thought if there is such a fundamental difference in approach, this was bound to give rise to legal disputes that might be worth looking at. But soon after I finished my PhD, of course, the pandemic began, so I couldn't really go to Cochin. So I instead just started looking online to see if certain cases had made it to publish law reports or were available online. And what I found was that while I didn't really find any cases pertaining to Cochin itself, I began to see that there was a sort of proliferation of cases involving water rights and fishing rights that were coming up for consideration before higher courts all across British India. So whether it was Madras, whether it was Calcutta, whether it was Bombay, high courts in each of these places were dealing with cases where the question that was under consideration was what kind of rights can one in fact claim over water legally, and what kinds of rights can one claim over fish. And if I can sort of anticipate the argument that I'm going to be fleshing out for the rest of this talk, what I realized after looking at some of these judgments was that the assumption that Abraham Salem makes in this report, that that in English law, land and water are considered to be completely different, and that you can't really own water in the way that you can own land, I realized that this wasn't entirely accurate. Because by the end of the 19th century, what you're really seeing through the judgments that I'm going to be discussing is that courts are, in fact, firstly blurring the legal line between land and water. And secondly, courts are in fact making space for exceptional private rights over public waters in India. So I wrote an article based on this research that's now available on open access, if anyone's interested. And in this article, I looked at about, I think, 10 to 12 cases involving fishing rights. And sort of important judgments pertaining to fishing rights from different parts of British India. For the purpose of today's talk, I'll of course not talk about all 12 of these cases. Instead, I've picked out 3 cases that I think are especially sort of important in order to see the changing sort of legal rationale and the way in which judges sort of start dealing with these questions, ultimately paving the way for the creation of private rights and public waters in India. So the first case is from Western India, very close to Bombay, almost 20 miles to the north of Bombay. And this case is actually, this is not one case, but actually 2 related cases. The first one from 1871. So if I can very quickly sort of go over the sort of details of this case. So in this particular case, fishers from a village called Malvani or Malavani, as it's known in the judgment itself, had planted fishing stakes in the sea, about 1.5 miles off the coastline. And the dispute sort of begins when their neighbors or their fishers from a neighboring village called Manori had gone and had sort of sailed to the spot, and they had uprooted the stakes that their neighbors had planted. And they had done so claiming that they in fact had some sort of an exclusive right to fish in this part of the sea. So they claimed that a local revenue official had in fact granted them an exclusive right to fish in that part of the sea, and that is why they had sort of uprooted their neighbors' stakes. So the aggrieved Malvani fishers then take their neighbors to court. This case finally reaches the Bombay High Court. And the judgment in this case is very interesting, but it's fairly straightforward. Because since the defendants in this case, the Manori fishers, had claimed some sort of an exclusive right to fish in the sea, what the judges had to decide was whether there was any grounds for such a claim. And the judges, after going through, they cite various authorities from Roman law, from English common law, including Blackstone, who they cite extensively. And they say even a figure like Blackstone, who thinks that the right to property is so important, and he's such a foundational figure as far as the institutionalization of the right to property is concerned in England, even he, in his commentaries on the laws of England, famously said that there are some things that you cannot have property rights over, and there are certain things that must remain in common, and these are light, air, water, etc. So on the basis of this principle, the judges point out that not only have the Manori fishers not shown any evidence for suggesting that they do have an exclusive right to fish in the sea, but they also pointed out that it is almost impossible for anyone to claim an exclusive right to fish in the sea. And so this is the end of this particular case. The Manori fishers are in fact convicted on the charge of mischief in this particular case. But while this is the end of this case, this doesn't really put an end to the dispute itself. And the following year, the Manori fishers are back at it, but this time they return with a slightly changed strategy. So if on the in the first instance, they had gone and uprooted their neighbors' stakes, this time they go and simply plant their stakes right next to the stakes that had already been planted by the Malvani fishers. And if on the first occasion they had claimed some sort of an exclusive right to fish in the sea, this time they said that they were simply exercising their common right to fish in the sea. So if, as the judges had stated on the previous occasion, the right to fish in the sea is held in common, they said that, well, then they should have the right to plant their stakes wherever they wished. And so this judgment is a very lengthy judgment, and this is a really interesting judgment. And in the article that I wrote, I spent a fair bit of time discussing this judgment, and there are 2 reasons for it. One is because this judgment becomes a precedent for a lot of later cases, including some of the ones that I'm going to mention later in this talk. And secondly, because in this judgment, you begin to see a particular line of legal reasoning. At least from all the cases that I looked at and all the judgments that I looked at, this provided the clearest sort of articulation of a line of legal reasoning that would become absolutely critical for the creation of private rights in public waters later on. And so if I can quickly sort of highlight a few things about this judgment. So this was judgment provided by a two-judge bench of the Bombay High Court, but the most substantial portion of this judgment was provided by the Chief Justice of the Bombay High Court, Westrop. So Westrop sort of spends a lot of time discussing the enduring ambiguities surrounding water law in both Roman and English common law, and he sort of goes into great detail about what some of these what some of these ambiguities are. But in his own judgment, there's a certain sort of confusion over categories that I thought was very interesting, which is that there was sort of the categories of public property and common property are almost used interchangeably. So the two judges in this case seem to use these categories interchangeably. But more importantly, they conflate the two with state property or with state ownership. So public property in the judgment is read almost as state property. And this is important because usually when we use the term public property, a public road, a public park, we usually think of property vested in the state for the benefit of the public. But in his judgment, Westrop begins to sort of question whether public waters in India are in fact for the benefit of the public. And he sort of raises this question by going into the history of the common right to fish in the sea. And he asks, where does this right come from? Where did this right come from in England? And then by citing various sources, he then says that this right in England comes from Magna Carta, and that before Magna Carta, because the bed of the sea and other water bodies was vested in the crown, the king could exclude the public and make private grants in rivers and other such water bodies to private landowners. But he says that Magna Carta put an end to this practice in England. So after this sort of discussion of the English context, he then turns to India, and then he says, well, in India, Magna Carta doesn't apply. And so he sort of puts two and two together, and he says, well, if Magna Carta is the origin of the right to fish in the sea or in other large water bodies, and if India doesn't have Magna Carta, does this mean that in India the public doesn't have the same right to fish in the sea and in other water bodies? And so in this particular judgment, he himself acknowledges that he doesn't need to answer this question himself. Because of the nature of the dispute in question, he doesn't have to conclusively answer one way or the other. He just sort of leaves this floating as a question. But this question is subsequently taken up in other judgments, especially in judges from the opposite coast of India, so from the Bengal Delta, where there will be a proliferation of cases around fishing and fishing rights from Bengal in the 1870s and 80s. And in these judgments, this sort of logic that or this line of legal reasoning that Westrop offers is sort of taken up by later judges, and you begin to see the ramifications of this sort of logic in practice. So before I talk about these judgments, I want to just quickly say a couple of things. One is that this idea that the right to fish in public waters goes back to Magna Carta. Legal scholars have pointed out that this is in fact a legal fiction, and that there's nothing really in Magna Carta that suggests that this is where the right came from. But what is interesting is that if you look at any of the important sort of legal treatises on water from the 18th and 19th centuries from England, this had sort of permeated and become part of a sort of legal common sense. Most of these texts would talk about this Magna Carta connection as an established fact and as a well-known fact. And so that's one thing that I want to mention here. And the second thing I want to mention is that it wasn't an accident or a coincidence that that fishing rights and disputes over fishing rights become especially contentious in Bengal. Partly this is because, as you can see, the Bengal Delta is a really fluid landscape. And so that has the nature of the landscape itself meant that there was just a lot more sort of contention around water. But equally, Bengal is also the first sort of area where the British established. It's the first main center of power for the English East India Company. And it is here that the English East India Company first tries to introduce modern forms of private property in India through what is known as the permanent settlement in the 1790s. And in such a fluid landscape such as Bengal, the rights over or property rights through the permanent settlement could never be completely divorced from rights over water. And so there was a sense that the permanent settlement did come in some cases with certain rights over water, but it was quite unclear what these rights really were. But over the course of the 19th century, as the agrarian economy in Bengal begins to expand, what you begin to see is a lot of landowners who had been granted rights through the permanent settlement now trying to extend their rights over land to different water bodies as well. So if there's a river flowing through their estate, if there's a river adjoining their estate, now landowners try and assert more claims or greater claims over these waters than before. And so by the late 1850s, 60s, you slowly begin to see a few cases coming up before higher courts in Bengal, where courts have to decide and are having to rule on cases where landowners are trying to say that they can own or they own parts of large rivers, etc. And in some of the earlier judgments, the courts had largely ruled against these sorts of claims by landowners. And they had said that, much like in the case of the sea, it is not possible for the government to create a private right out of public waters like rivers. And this sort of this principle was also reinforced by a government order from 1868 or 1869, which said it was impossible for the government to make over the fishery rights in a tidal river to any individual to the exclusion of the public generally. So the sense was that you can't, much like in the case of the sea, you cannot own large water bodies. And this goes back to this idea that the materiality of water itself is such that it doesn't lend itself to conventional property rights. But following the Bombay judgment that I just discussed, and this sort of articulation of this principle relating to the Magna Carta that I just mentioned, you begin to see a shift in the way in which judges in Bengal are dealing with questions or dealing with cases involving water rights. And you begin to see judges making greater allowance for the possibility of rights over water that landowners can have. And so one of the most important cases, at least of the cases that I saw, the one that I thought was most influential was this case from 1885 involving a river. I won't really go into the details of the case itself, but the judgment in this case, this wasn't a unanimous judgment. It was a 5-judge bench of the Calcutta High Court with a 3-2 majority. However, in this particular case, the judges decide that in India, the situation as far as states' rights over waters is concerned was fundamentally different compared to England, and there is no limit on the Crown's ability to grant rights in navigable and tidal waters. And the court uses 2 sort of principles for coming to this judgment. It firstly uses the same Magna Carta argument that I already discussed, the fact that there is no Magna Carta in India, and Magna Carta is the origin of the public's right to fish. And so that becomes one way of creating rights over, allowing the Crown to exclude the public and to create private rights in waters. And the other equally important thing that happens in this judgment, this is actually not the first judgment to articulate this principle, but already this had begun to happen by the late 1870s. The court says that in India, the crown has the power of making settlements or grants for purposes of revenue of all unsettled and unappropriated lands. So in India, and this is something that scholars of South Asia have talked about, this category of unsettled and unappropriated lands, which are often classified as wastelands, were seen to be lands over which the colonial state had tremendous amount of power. And this, the court held, applied as much to lands covered by water as to those not covered by water. So in a sense, water bodies themselves are now being redefined simply as lands covered by water. As I said, this is not peculiar to this particular case. This is something that was happening more widely. But in this sort of context, these two sort of principles lead to two sort of consequences. One is you're sort of seeing this idea, this blurring of the legal difference between land and water. So now water and water bodies are now being talked about in reference to land. And that sort of legal distinction between land and water is being blurred. And through that, the court is now creating room for much greater private rights over public waters than is possible in England and many other places, saying that it is possible for the crown to make use of the vast powers that it has over these sort of unsettled lands to make space for private rights. But even this sort of the court's acknowledgement of and the court's strengthening of private rights over waters doesn't really put an end to the confusion or to disputes surrounding fish and fishing rights. In fact, in some ways, the court sort of siding with landowners on the question of water rights only adds to and accentuates disputes surrounding fish. And this is because there's a fair bit of confusion still over the kinds of rights one can claim over fish. So if there is confusion over water, there's even more confusion over the sorts of rights that are possible, that one can possibly claim over fish, because fish were considered to be res nullius, over which only possession could grant property rights. So as landowners begin to find by the 1870s, 1880s, that courts are siding with them in terms of and granting them rights over vast sort of over large water bodies or over large sections of water bodies like rivers, these landowners begin to try and use these rights to exclude other people from fishing in their waters. Now, for most people in Bengal and many other parts of India, these water rights, the most valuable right associated with water rights was the right to fish. That was considered to be the most valuable resource from these waters. And so you see this attempt on the part of landowners to enforce their rights over water by increasing their sort of, or trying to extend their rights over fish. But there was still a lot of confusion about whether rights over water did automatically extend to rights over fish. And so as a number of cases began to come up before high courts, not just in Calcutta, but in many other parts of India, where landowners were trying to sort of go after anyone caught fishing in their waters, courts were having to adjudicate on this question. That is, does somebody's right over water mean that they can now claim that the fish in these waters are their property? And judges would come to conflicting sort of decisions on this question. In the 1870s and 80s, while some of the earlier judgments seem to suggest that if you own a body of water, then that does mean that you do own the fish in these waters as well. In many other judgments, and this increasingly became the primary way of deciding these cases, in most cases, the question began to hinge on the nature of the water body in question. So if it was a fully enclosed body of water, then if you owned that water body, then you could claim that you own the fish. And the reason was that the idea was that the liberty of the fish had been curtailed. The fish were trapped in waters that you owned, and because they couldn't really leave, that meant that you could claim that you had possession over the fish during that time. But in cases where you only owned a section of a river, say, or you had some grants, you had been able to prove that you had a grant that gave you rights over a section of a river, or if you owned a water body that tended to flood during certain seasons of the year, and that would overflow or breach its banks. In these cases, because the liberty of the fish wasn't curtailed, your rights over water would not extend to the rights over fish. And so this became the usual. So by the mid 1880s, there was a sort of consensus among judges that this would be how these cases would be decided. And this began to cause a fair bit of confusion and frustration among landowners, who began to think that what the sort of courts had granted them with one hand, which is allow for greater rights over water, they were taking away with the other by making these rights almost unenforceable in the case of fishing rights. And this sort of frustration reaches a sort of fever pitch following yet another judgment. And this is the last judgment that I'm going to be discussing today. This was a case which is quite well known. This is known as the Meharpur case. And just like the Bombay judgment that I talked about at the start, this is actually not one case, but two cases. But I'll just talk about the second one. Now, I must point out here that the water body in question here is very different to the sorts of waters that I've discussed previously. So in the first case, we're talking about the sea. In the second case, the dispute was about a river. Now, in this case, it's a sort of shallow body of water that is privately owned, locally known as a beel. It's more like a small pond, and it was privately owned. And this particular dispute begins when the landowner who owned this beel, he wrote to the local administration to tell them that on the occasion of the Bengali New Year, there was a customary practice in this region where people would congregate around water bodies like this, and they would fish on that particular day. And he wanted the administration to prevent this from happening. And so he writes to the district collector and he says, make sure that people don't fish in these waters. And the local administrator at that time turned out to be this very young and overzealous person who makes a lot of arrangements to prevent people from fishing in these waters. 3,000 odd people still congregate. Some of them fish in these waters. And many of them are arrested. And this case gains a lot of attention because not only are some people arrested, some people are also whipped. And so the violent punishment sort of meted out to people who were basically just following a customary practice attracts the attention of the local press. And so this case starts becoming quite infamous in Bengal during this time. Now, when the case reaches the High Court, the judges rule against the government and rule against the landowner by stating that even though this particular beel was enclosed, even in this case, the offense of theft could not have been committed because the fish said to have been stolen were not the subject of anyone's property. They were wild fish in a natural lake. And so the idea that what the judges in this case, so they go into various aspects of res nullius and the importance of recognizing fish as things that you can't really possess. And then they say that because in this case, this is a natural water body, you cannot have property rights over the fish in these waters, even if you own the water body in question. So this case causes a huge amount of outrage among landowners who say that if this principle were to become well established and well known, this would render all sort of private rights over water completely redundant. And they begin to paint the sort of picture of a complete chaos and nobody sort of heeding private property rights whatsoever. And they start lobbying the colonial administration to pass legislation. So they say if under the existing laws you can't deal with this situation, we need new legislation. And so it's in this context that the government passes the Bengal Private Fisheries Protection Act of 1889. And this act is really interesting. So some people have written about this act as part of a rising sort of conservationist discourse in India. So this is the time, the late 19th century is of course a time when the discourse of conservation starts gaining ground. And so some people have written about this act as being part of that sort of move. But when you read the sort of debates and discussions leading up to the passage of the act, it becomes clear that the main motivating factor behind this act is the need to reconcile or to overcome and resolve some of these contradictory pulls of preceding judgments. So on the one hand, judgments had granted landowners significant rights over water bodies, but at the same time, the fish itself were turning out to be very slippery in terms of property law, and it was becoming very hard to extend the rights over water to fish. And so in this particular act, the way in which water rights are extended to fish is through a strengthening of rights that people can claim over water itself. And so this act introduces this category of private waters, which is again a really interesting sort of category, because this category, the term private waters is defined in this act on the one hand very broadly. So it's the sort of all-encompassing sort of definition almost. So it could be any kind of water body, any waters which are private property or in which any person is entitled to an exclusive right of fishery. So this could apply to any a natural water body, an artificial water body, a section of a river. All of these would be included. But this act also very specifically makes allowances for water bodies that are unenclosed, because that was the problem that many of these cases, or that was the principle that was creating problems for landowners in a lot of previous cases. The fact that the water body was not fully enclosed, and so it specifically says that if it's a even if it's a water body in which is not enclosed, this act would apply to those waters as well. And it sort of punished any sort of fishing in these waters with imprisonment, which is what landowners wanted. They wanted to bring this under criminal law rather than just civil law. And so, and I'm going to end with this, and this act had a far-reaching and very swift sort of impact on fishing across Bengal, and then this is applied to other places as well. So much so that in the early 1900s, one sort of, I think he was a civil servant, Kiran Chandra Dey, he noted that as a result of the act, there were no more free fisheries in which the public had the right to fish without license except in the sea. So all other waters in some form or the other had been in some form, in a way you can say, had been privatized. So I'm going to end there, and I look forward to your questions.